Well, good morning. Uh, this is going to be the fourth video I put out uh, regarding policies and procedures at the Bastrop Central Appraisal District that are illegal. Today, I'll be talking about their policy of having productivity or production requirements for qualifying for open space appraisal. This um, applies mostly to open space appraisals this time. Um, and we're going to only be talking about one of their illegal policies, that one of production requirements. So first of all, I want to point out that the rules that they have um, are actually agency rules. Those are rules, agency rules. And uh, the Bastrop Central Appraisal District is an agency, and the Constitution says that agencies don't have any authority unless it was given to them by the Constitution or a law. And that same thing applies with appraisal districts. And appraisal districts can make rules, but since they don't have any authority that is not given to them by law, they can't make any rules that aren't already in the law. So that's come through in lots of court cases, but I'm showing you here one that came from actual Bastrop Central Appraisal District. And the the language they use is that it's this the taxpayer's name was Allmeter. It says Allmeter was required to raise a fact issue as to whether the district standards impose additional burdens, conditions, or restrictions that exceed relevant statutory provisions. So that language is used in all these court cases, and there's a ton of them, that says agency rules cannot have any burdens, conditions, or restrictions that aren't already in the law. So let's look at the law. And the law about open space appraisals, the part that we're interested in is right here in 2351 of the property tax code. And it is for the qualifications for open space land. And there it says basically that the open space land must have an agricultural use. And then down below, it defines the word agricultural use, those words. And for our purposes here, agricultural use says raising or keeping livestock. And I want to stress that it says raising or keeping. So merely keeping livestock is an agricultural use by the law. That's in the law, and you don't notice anywhere in here any other burdens or restrictions to qualify for open space land other than keeping livestock. So let's see what the Bastrop Central Appraisal District's agency rules say. Here is their Ag Guidelines Manual, and they, under their principal agricultural use, they kind of put a definition that is kind of the same as the law. Land must be currently devoted principally to agricultural use, and it's to the degree of intensity generally accepted in the area. But the agricultural use, is what we're interested in now. And here they have qualifying activities and non-qualifying activities. Under qualifying activities, they say raising livestock, such as cattle, horses, goats, swine, poultry, and sheep. But they didn't say keeping livestock. Well, we just read in the law that keeping livestock is a qualifying activity, but here they have created their own restriction that now only raising livestock is a qualifying activity. So that would be a restriction that they put in their agency rules that is not in the law. And then under non-qualifying activities, they say it's non-qualifying to keep or use horses in some manner that is not incidental to breeding or raising horses. So they have another burden and condition and restriction about qualifying for open space land, and they have the land must be used for breeding, or to keep horses in some manner that is not incidental to breeding is a non-qualifying activity. So they have another restriction in there that is not in the law. So now I want to show you a court case that actually considered this very specific issue. And I want you to remember the name of it. It's Kerr Central Appraisal District versus Stacy. And when they put the first party's name is the one that it brought the appeal. In this case, the appraisal district appealed this case. So that means in the trial court, in the district court, the appraisal district lost. And so then the appraisal district brought this up for appeal. And they say the primary question that they were considering on this appeal is whether the property, which is leased for the sole purpose of grazing horses, which are used only for recreational purposes, qualifies as open space land. So they're considering this one particular issue. Sometimes when you refer to cases, you refer to something that wasn't really the main issue in the case. But in this case, this whole case, the main issue is, does this land qualify as open space appraisal, even though the horses that are on there grazing are only used for recreational purposes. So that's what they're trying to decide. And I'm going to read this out. It says here, we are faced with two opposite interpretations of the same seemingly straightforward statute. On the one hand, the appraisal district advances a product theory, which would require a landowner to show that some agricultural product was produced in order to qualify for open space valuation. On the other hand, the Stacys submit that it is not the product of the land which is determinative. Rather, it is the use of the land which must be scrutinized. This argument can be characterized as a use theory. So they have a production theory and a use theory that they're being approached with. It says the appellant, which is the appraisal district, would have this court interpret the statute to require a landowner to actually show that an agricultural product has been produced on the land in order to fall within the boundaries of farm or ranch purposes. For the reasons set forth below, we decline to adopt such a harsh, far-reaching standard. So they're already telling you that they do not require a production requirement is not necessary to qualify for open space land. And in their kind of summation, they said, simply because the horses in the instant case are used for recreational purposes does not indicate that the land itself is being used for recreational purposes. So basically, they're saying the use of the livestock is irrelevant. It's the use of the land. And in this case, the use of the land was for grazing horses or keeping horses. They weren't raising horses. They were just keeping them there. And so that qualifies for open space appraisal, and they have forbidden appraisal districts to have production requirements. So that was a case law that came about in, it was decided in 1989. And the comptroller's office gives advice to appraisal districts, and actually the law says the appraisal districts are required to comply with the comptroller's advice. Well, there were a comptroller's manual came out in 1988, and it contained, well, there was a comptroller's manual that gives advice, has these, the comptroller's manual on granting open space appraisals. They did it in 1982, in 1988, and again in 1990. And in 1990, the comptroller's manual had the wording that, just like the Bastrop Central Appraisal District says, that must be a breeding operation. Its breeding operation is a requirement. That was in the comptroller's manual. But it was a mistake, because in 1989, the Kerr versus Stacy case came about. And so when they printed the comptroller's manual in 1990 and said they must have a breeding operation, that was a mistake. So the comptroller's office would have to regularly put out reminders to appraisal districts and chief appraisers that, okay, you saw this in the comptroller's manual, but it was a mistake. And they have to remind them it was a mistake. You have to go by the law. And here's a reminder that they sent in 2013. And it says the livestock only must be raised or kept on the property. No other requirements exist in the statute or comptroller rule regarding the use of livestock. So they're just putting this reminder that even though that they didn't change that in 2012, by 2012 or 2013, they had not changed their 1990 manual. In fact, they didn't change it for 27 years. But so when they first came out, they were putting probably having to put this reminder out lots of times. chief appraisers may change every few years. If they didn't put it out for 20 years, they put this reminder out 23 years after they made that mistake and published that mistake. So they were having to do it pretty regularly. And as chief appraisers would leave, and they kind of have to remind them that, okay, there's no other requirements in the statute or the rule. And that comes from there's no other requirements from the case law that says agency rules cannot have any requirements that are not in the law. Okay. So the comptroller's office also responds to inquiries. And here's an inquiry. Most of the inquiries they get actually come from chief appraisers or somebody at an appraisal district office that has a question. But anybody can actually write to them and ask them a question. So somebody did this in 2012, and it says in reading the 1990 manual, it states that horses do not count as agriculture exemption if they are not bred. So that's the question that they sent to the comptroller's office, and the director of the Property Tax Assistance Division was Deborah Cartwright at the time, and she is the one responding to his inquiry. I'm going to read this whole thing. Please note that a 1989 court decision overturned that provision in the manual, adopted in 1988 and amended in 1990 without addressing the 1989 case. In Kerr Central Appraisal District versus Stacy, and they give the number, held that property used for grazing horses was open space land, even if no agricultural product was produced, and even if the horses were only used for recreation. And they had actually circled that. And then the court continued by stating that agriculture use and farm or ranch purposes do not require use of the land for the production of agricultural products. So you can see here that they say this Kerr versus Stacy case actually overturned that provision that they had in their manual by mistake, because the court case came about in 1989 and their manual that came out in 1990 just failed to remove that part. And then it says it doesn't matter what the horses are used for, even if they're only used for recreation. It makes the use of the livestock is irrelevant. It's the use of the land that matters. And they said to have an agricultural use does not require any kind of production. There are no production requirements to qualify for agricultural use. So it seems kind of clear. The law says that just keeping livestock qualifies you for open space appraisal, and the Bastrop Central Appraisal District has further restrictions and saying you must have a productivity requirement. You must be to have a breeding operation, and those are restrictions and burdens that are not in the law, and so they are void. They're not even allowed to have those kind of restrictions in their agency rules. And so it's, they're just in violation of the property tax code. But putting that in the property tax code and publishing it in their official government document actually has some criminal implications. I'm going to go over some of them. Under the Penal Code 3903, official oppression, a public servant acting under color of his office or employment, and that would be an appraisal district employee or the chief appraiser, commits an offense if he intentionally subjects another to assessment that he knows is unlawful. An offense under this section is a Class A misdemeanor. Well, if they cause an appraisal to cause his an assessment that he knows is unlawful, and he knows that they know it's unlawful because it's in the law, they've been advised about it by the comptroller's office over and over again, and they are required to enforce the law, not their agency rules. In fact, their agency rules can't have any restrictions that are not in the law. Another thing that it would be a violation of is abuse of official capacity. A public servant commits an offense if, with intent to harm or defraud another, he intentionally or knowingly violates a law relating to the public servant's office or employment. Well, this law about not having agency rules is a law relating to the public servant's office or employment, and that is a state jail felony. Also, when they published this in a governmental record, they violated 37.10, which is a person commits an offense if he makes, presents, or uses a governmental record with knowledge of its falsity. There's no doubt that they knew of its falsity when they put it in their governmental record with their Ag Guidelines Manual, which is a governmental record. And if they get together to do that with 3 or more people, like the chief appraiser, the ag advisor, the on-site inspector, or other people at the office, or even the board of directors, to get to where there's more than 3 people that are enforcing this, a person commits an offense if, with the intent to participate in a combination, the person commits or conspires to commit one or more of the following, and tampering with a government record is right there under number 13. And the penalty for doing it as a group, it makes it 1 category higher than the most serious offense. So I'm going to unshare this now. Well, how do I unshare this? Now I can't see how to do it, how to unshare it. Oh, here we go. So now I should be not sharing my screen. And I just want to sum up what we've talked about. The enforcement of production requirements is illegal. We saw the law. We saw that they're doing it. It directly contradicts case law, which prohibits agency rules from exceeding statutory provisions. And the law contains no production requirements. Yet the appraisal district imposes them, making their policy unlawful. And the Texas courts have explicitly ruled that appraisal districts cannot impose production requirements. The appraisal district has been repeatedly warned, yet they continue to enforce their illegal policies. You saw that the comptroller's office has advised all appraisal districts that they cannot impose rules that are not in the law. And the comptroller specifically confirmed that the Stacy case overturned the breeding operation requirement mistakenly included in the 1990 comptroller's manual. Despite this, the appraisal district, Bastrop Central Appraisal District, refuses to comply with the law and continues publishing illegal production requirements in its agricultural guidelines manual. This isn't just bureaucratic overreach. Bastrop Central Appraisal District officials are committing crimes. By knowingly enforcing illegal policies, they're violating multiple criminal statutes, including official oppression, abuse of official capacity, tampering with government records. So what can we do? What can the public do? The main thing is to spread the word. Share this video so more people understand how Bastrop Central Appraisal District is breaking the law. And it's probably not just the Bastrop Central Appraisal District. I believe many appraisal districts are doing the same thing. And demand accountability. Ask the appraisal district why they are still publishing illegal production requirements. Challenge unlawful denials. If you or someone you know was denied open space appraisal due to a production requirement, challenge it. Take it to court. Take it to the appraisal review board. And something else you can do is something else you can do is to file a complaint with the taxpayer liaison officer. Anyone who sees the appraisal district's illegal production requirements can file a complaint with the taxpayer liaison officer, even if you have never applied for open space appraisal, even if it doesn't have anything to do with it. You're not filing a complaint that they appraised your property differently than the law. What you're filing a complaint about is that they have agency rules that are in violation of the law. You're complaining that if the appraisal district illegally publishing the production requirements and report that they are inserting unlawful criteria into, and then they put that unlawful criteria into a governmental record. Make that complaint. Make the complaint that they're illegally publishing them in a governmental record. The taxpayer liaison officer is required to investigate and resolve every complaint. Every complaint must be publicly reported at a board of directors meeting, along with the resolution. The Bastrop Central Appraisal District Board of Directors has banned me from making public comments about their illegal policies and practices, but they cannot silence a formal complaint to the taxpayer liaison, which they must publicly acknowledge in board meetings. So I put it up here on the screen, an email address to post a complaint to the taxpayer liaison officer, tlo@bastropcad.org. That's all it takes. You can write a complaint, probably in less than 10 words, to complain that the appraisal district has illegal production requirements. I would like for and the taxpayer liaison officer has to report every single one of those complaints at a board meeting. When she reports them, she has them on a little chart that has about maybe 15 or 20 on each page. I would like for her next report to take up 200 pages of individual reports from everybody that has complained that the Bastrop Central Appraisal District has illegal production requirements. So the law is clear. The courts have ruled. The comptroller's office has advised appraisal districts they can't impose production requirements. Yet the Bastrop Central Appraisal District continues to ignore the law and illegally impose these burdens on property owners. This isn't just a policy dispute, it's a violation of the law. The chief appraiser does not have the integrity to hold herself accountable, so the public must demand it. Please do. Thank you.